Good morning, everybody. Welcome to your History and Civics class. We are on lesson number 3, the Indian Judiciary, which means the law protecting body of the Parliament. Let us see the objectives that we have covered. Number 1, the introduction to judiciary. Number 2, independence of judiciary. Number 3, how is independence of judiciary ensured? And number 4, the structure of the judiciary. I hope you remember the terms that we have done in our previous video. Let us recall them one more time. Judiciary, jurisdiction, executive, interpret, fundamental rights, Supreme Court, High Court, subordinate court. Students, you must know the answers to all these terms. Now I'm going to ask you a few cross questions. Give the answers of all of them. The judiciary is one of the principal organs of the government. How is independence of the judiciary ensured? Name the apex court of the country. The removal of a judge requires majority in the parliament. The framers of the constitution have kept the judiciary. Children, the objectives of today's class are: we will learn about the Supreme Court, the Chief Justice of India and other judges of Supreme Court, their qualifications, tenure, powers and functions of the Supreme Court, and under the power and functions we will learn the various powers, and they are original jurisdiction, appellate jurisdiction, advisory jurisdiction, supervisory jurisdiction, revisory jurisdiction, court of record, and judicial review. The technical terms that we have to learn in today's topic are Supreme Court, the apex court of the country; appellate jurisdiction, the power granted to a higher court to hear appeals against the judgment of lower courts. Number 3, original jurisdiction, the power granted to certain courts to hear cases in the first instance. Jurisdiction, the official power to take legal decisions and pass the judgments. Collegium, a group comprising the Chief Justice of India and 4 senior-most judges of the Supreme Court who select judges of the Supreme Court. Writs. A writ is a formal written order issued by a court, that can be Supreme Court and a High Court of India, that requires specific action by the person or entity to whom the writ is directed. Court of Record. A court of record is a court whose acts and proceedings are printed and kept in record for future references in the court. Criminal cases. The cases that involve violation of law like violence, physical assault, murder, etc. Civil cases. The cases that involve conflict between people, case related to land, property and monetary transaction, marriage, divorce, will, etc. These terms are very important, children, and you're going to read them many times in the lesson ahead, so please learn them wisely. Supreme Court of India is the supreme judicial body of the government of India and the highest court of India under the Constitution. It is the most senior constitutional court and has the power of judicial review. Judicial review is a process under which executive or legislative actions are subject to review by the judiciary. It was established on 1st October 1937, 83 years ago, during the British Raj as Federal Court of India, and on 28th January 1950, that is 70 years ago, as Supreme Court of India. The Supreme Court is situated in New Delhi. The composition, appointment of the judges of the Supreme Court. The Supreme Court of India consists of a Chief Justice and some other judges, the number of which may be fixed by the Parliament from time to time. At present, it consists of the Chief Justice and 30 other judges, that is, total 31 judges. The Chief Justice and other judges of the Supreme Court are appointed by the President. But the President does not have a free hand in this matter. He must consult the Chief Justice of the Supreme Court before appointing any judge to it. In the matter of appointment of the Chief Justice of India, he shall consult such judges of the Supreme Court and of the High Court as he may deem necessary. But children, over the years, a convention has developed whereby the senior most judge of the Supreme Court is appointed as the Chief Justice of India. Now let us see the qualification required to become a judge or the Chief Justice of the Supreme Court. For that, a person should possess the certain qualifications, and they are that he must be a citizen of India. He must have worked as a judge in any of the high courts continuously for not less than 5 years, or he must have been an advocate of a high court for at least 10 years. Or he should be a distinguished jurist in the opinion of the president. Distinguished jurist means a person with expert knowledge of law. There is no clear provision as to who shall be appointed as the Chief Justice of India. As discussed earlier also, generally the senior most judge of the Supreme Court is appointed as the Chief Justice of India. Next, we have to discuss about the term of the office of the judges and removal of the judges of the Supreme Court. The Chief Justice and other judges of the Supreme Court are appointed to work till they attain 65 years of age. Although they are appointed by the President, their services cannot be terminated by him. They can resign from their post of their own whenever they like. Death, of course, can be another cause of the end of their service before the age of retirement. But in case if a judge of the Supreme Court is found guilty of misusing his powers or of acting against the provisions of the Constitution, he can be impeached and relieved of his office. The procedure of impeachment of a judge is almost the same as that of the President of India. Children, please take out page number 152. Let us read from the Supreme Court. The Supreme Court is the highest court and is situated in New Delhi. It is composed of the Chief Justice of India and 30 other judges. You may underline this line also. The number of judges can be changed by the Parliament from time to time. The President appoints the Chief Justice of India after consulting other judges of the Supreme Court and the High Courts. The seniority of a judge is also an important factor. Other judges are appointed on the recommendation of the Collegium. The Supreme Court's Collegium is a group. This is the meaning of Collegium, children. Please underline. The Supreme Court's Collegium is a group which comprises the Chief Justice of India and a group of 4 senior-most judges of the Supreme Court. The President administers the oath of office to all of them. Oath means it is a formal promise, especially a promise to be loyal to a person or country. Qualifications: to become a judge of the Supreme Court, a person must be a citizen of India, have been a judge of a high court for at least 5 years, or have practiced as an advocate in one or more high courts for at least 10 years. An advocate is a professional in the field of law, or be an eminent jurist in the opinion of the President. Eminent jurist is a person with expert knowledge of law. Tenure: a judge of the Supreme Court holds office till her or his retirement or till the age of 65 years. She or he may leave the office before her or his tenure by submitting her or his resignation to the President of India. She or he can be removed on grounds of misusing the office, proven misbehavior, or incapacity by 2/3 majority in both the House of the Parliament. Now let us do the jurisdiction, powers and functions of the Supreme Court. The Supreme Court of India, being the highest court in the country and being at the head of the entire judicial hierarchy in the land, has to perform many judicial, administrative, advisory and other functions. Let us start from original jurisdiction. Original jurisdiction of a court implies those cases which could be directly brought before it. The Supreme Court of India has original jurisdiction over certain cases. Let us discuss them one by one. Number 1. Interpretation of the Constitution, which makes the Supreme Court the custodian of the Constitution as well. And this power is also known as the power of judicial review. All the cases where interpretation of the Constitution is required can be directly filed in the Supreme Court. Interpretation means action of explaining the meaning of something. The Supreme Court has the power to review and to decide whether a law passed by the legislature is beyond one's legal power or authority. Next is the center-state dispute. All the disputes between the center on the one hand and a state on the other fall within the original jurisdiction of the Supreme Court. Next is disputes between two or more states. Disputes between two or more states also make a case for original jurisdiction of the Supreme Court. Like we have already discussed in our previous video, the sharing of waters of the Kaveri River has been the source of a serious conflict between the two states of India, that is Tamil Nadu and Karnataka. The water sharing dispute of the river between Karnataka and Tamil Nadu dates back to the British Raj. Children, regarding the state and the center dispute and the state dispute, the Supreme Court has the exclusive jurisdiction. In other words, none of the disputes can be decided by the other courts. Such a power lies with the Supreme Court and none of the other courts. Cases related to the violation of the fundamental rights guaranteed by the Constitution can originally be brought before the Supreme Court. Article 32 of the Constitution gives an extensive original jurisdiction to the Supreme Court in regard to enforcement of the fundamental rights. The Supreme Court also acts as the guardian of the fundamental rights by declaring any law that infringes upon these rights null and void. If the Supreme Court observes that the fundamental rights as given in the Constitution are being violated, it is empowered by Article 32 of the Constitution to issue writs to enforce them. A writ is a legal document issued by the court directing a person to do or not to do something. Children, we will discuss about the writs in our next video in detail. The next jurisdiction power of the Supreme Court is appellate jurisdiction. The power of the higher court to review the decision or change the result of the decisions made by the lower courts is called appellate jurisdiction. The Supreme Court in India is the highest court of order in the country. It can hear appeals in cases like civil cases and criminal cases. Civil cases are the cases which involve conflict between people. For example, breach of contract, property dispute or marriage dispute, etc. Criminal cases involves violation of law. For example, murder, theft, robbery, they are the example of criminal cases. Let us see the cases that can be brought before the Supreme Court only through an appeal. And those cases are, number 1, criminal cases. A criminal case where a person is acquitted by the session court. Acquitted means free from a criminal charge. By the session court, a court of session is the highest criminal court in the district, but awarded capital punishment. Capital punishment is the legally authorized killing of someone as punishment for a crime. By the High Court, can be brought on appeal to the Supreme Court. In simple words, it means a person who is free from a criminal charge by the session court but is awarded a death penalty, that is capital punishment, by the High Court, then his case can be brought by an appeal to the Supreme Court. Next case, an appeal can be made to the Supreme Court where a High Court withdraws a criminal case from a lower court, that is any subordinate court, convicts a person and awards him capital punishment. A case where a High Court itself certifies. Certifies means to make it official that a particular case involves a substantial point of law. Substantial point of law means a question of law will be a substantial of law if it directly and substantially affects the rights of the parties. In order to be substantial, it must be such that there may be some doubt or difference of opinion, or there is room for difference of opinion. So in that case, High Court will itself call for the interpretation of the Constitution. Interpretation means action of explaining the meaning of something. Page number 153, let us do the reading of the jurisdiction, powers and functions of the Supreme Court. First of all, let us see the meaning of jurisdiction. Jurisdiction means the extent of the power to make legal decisions and judgments. Now let's do the reading. Jurisdiction implies the extent of legal authority. the Supreme Court exercises different kinds of jurisdiction, and these are as follows. Number 1, original jurisdiction. The cases that come directly to the Supreme Court without being taken to any other court fall under original jurisdiction. Children, this is the definition of original jurisdiction. The Supreme Court exercises original jurisdiction over the following cases. Number 1, disputes between states and center or one or more states. Number 2, the cases involving violation of fundamental rights by the government or any of its agencies or any individual. It can issue writs for upholding and enforcing the fundamental rights granted by the Constitution. A writ is a legal document issued by the court directing a person to do or not to do something. Number 2, appellate jurisdiction. It is an appeal against the judgments of the lower courts to the Supreme Court. Again, this is the definition of the appellate jurisdiction. You may underline it. The Supreme Court exercises appellate jurisdiction over the following cases. Number 1, a petition filed against the decision of the High Court in civil and criminal cases. Number 2, the cases where the High Court itself confirms that the case requires an important point of law and calls for an interpretation of the Constitution. Number 3, the cases where the High Court changes a decision of the lower court and awards a death penalty. Death penalty means capital punishment. Another very important function of the Supreme Court of India is its obligation to advise on constitutional as well as other matters of law to any government department, legislature, the President or the Council of Ministers, whosoever seeks it. It should be kept in mind that the advice rendered by the Supreme Court shall in no way be binding on its seeker. In other words, it means if at any time it appears to the President that a question of law or fact has arisen or is likely to arise, which is of such a nature and of such public importance that it is necessary to obtain the opinion of the Supreme Court upon it, he may refer the question to that court for consideration, and the court may, after such hearing as it thinks fit, report to the President its opinion thereon. However, it is not binding on the Supreme Court to answer questions raised in the reference. This is known as its advisory function. Page number 154, reading of advisory jurisdiction. The Supreme Court advises on constitutional and other matters of law to any government department, legislature, the President or the Council of Ministers. The President is not bound to abide by the advice of the Supreme Court, but when the advice is related to the federal structure, that is, center and state relations, the President is bound to follow it. Supervisory jurisdiction. The supervisory jurisdiction of a Supreme Court involves a duty on the High Court to keep the inferior courts and tribunals within the bounds of their authority and to see that they do what their duty requires and that they do it in a legal manner. Revisory jurisdiction of the Supreme Court. The Supreme Court is the final interpreter of the Constitution. Hence, only the Supreme Court has the power and the right to revise its earlier decisions and give a new decision contrary to earlier one. This provision is given because human judgment is fallible. Fallible means capable of making mistakes, and the apex court may rectify something that was misjudged. Rectify means to correct. Situations may arise in future which require reconsideration of a final judgment already delivered. Under the Article 137, the Supreme Court is empowered to review any judgment or order made by it with a view to removing any mistake or error that might have crept in the judgment or order. On the same page, let us do the reading of supervisory and revisory jurisdiction. Supervisory jurisdiction. The Supreme Court also supervises the work of the high courts and the subordinate courts. This is called supervisory jurisdiction. Revisory jurisdiction. The Supreme Court also has the power to review any order or judgment which has been passed by it earlier. The Supreme Court can rectify a mistake or decision made previously. The Supreme Court acts as the court of record also. All the decisions and decrees. Decree means an official order that has the force of law issued by the Supreme Court are duly printed and kept in record for future references in the court as well as for the use of lawyers in their pleadings. Important decisions by the High Court of the land are also kept in record for future references by the Supreme Court. How is the Supreme Court a court of record? Article 129 of the Constitution of India declares Supreme Court to be a court of record. As a court of record, it has two powers. Number one, the judgment, proceedings, and act of Supreme Court are recorded for permanent memory and testimony, and these records can be produced before any court because they have evidentiary value and they cannot be questioned. Number two, it has the power to punish for its contempt. Contempt means insult, either with simple imprisonment for 6 months term or with fine. Let us do the reading of the Court of Record. The Supreme Court is a court of record. A court of record is a court whose acts and proceedings are printed and kept in record for future references in the court. Proceedings means a procedure through which one seeks redress from a court or agency. Article 129 in the Indian Constitution makes the Supreme Court a court of record. Next is one of the significant jurisdiction power of the Supreme Court, and that is the judicial review. The judiciary plays a very important role as a protector of the constitutional values that the founding fathers have given us. They try to undo the harm that is being done by the legislature and the executive, and also they try to provide every citizen what has been promised by the Constitution under the directive principles of state policy. Now, what are the directive principles of state policy? Directive principles are the guidelines given to the government to run a welfare state. All this is possible thanks to the power of judicial review. The rule of law is the bedrock of democracy, and the primary responsibility for implementation of the rule of law lies with the judiciary. This is now a basic feature of every constitution which cannot be altered even by the exercise of new powers from Parliament. It is the significance of judicial review to ensure that democracy is inclusive, that there is accountability of everyone who exercises public power. India has opted for parliamentary form of democracy, where every section is involved in policy making and decision taking, so that every point of view is reflected and there is a fair representation of every section of the people in every such body. In this kind of inclusive democracy, the judiciary has a very important role to play. Thus, the Supreme Court has judicial review power that is being vested through Article 13 of the Constitution, which means it can strike down any legislation and executive action if such acts are found to be inconsistent with the Constitution of India. Page number 154, Judicial Review. Let us first see the meaning of the term judicial review. Judicial review is a power of a court to decide whether a law or decision made by the government is constitutional. To determine the constitutional validity of any law is in the hands of the Supreme Court of India. The constitutional validity means the Constitution is the basic law of the land. In other words, all the other laws have to be in conformity with the Constitution. Any law that is not in conformity with the Constitution is invalid. Judicial review is the power of the judiciary by which the Supreme Court determines the constitutional validity of the laws and rules of the government, and the court can reject that law or any of its part which is found to be unconstitutional or against the Constitution. Okay, children, now this is the end of the class. We have learned about the Supreme Court and its various functions like appellate jurisdiction, original jurisdiction, advisory jurisdiction, supervisory and revisory jurisdiction. Supreme Court act as a court of record and Supreme Court's judicial review power. Children, if you have understood the video very well, then hopefully the next video, which is of High Court, is also going to be easy for you to understand, as there are many points that are similar. Read page 152, 153 and 154 of your book. Find out the related back exercises and try to solve them. Don't forget to learn the related terms of the lesson. Follow the school link on YouTube for watching the videos. Take care. Bye-bye.